Hey guys, happy Friday. This is like part 15 of our deep dive into the Zachary Adams, Holly Bobo case, all the stuff pre-trial. It's our third video on going back all the way to the beginning, the day of the abduction, and looking at the contemporaneous media coverage and any courtroom proceedings that were taking place. So we are now going to be towards the end of 2016. As a quick refresher, and if you want to go back and watch part 1 and part 2 on the media stuff, that's linked in the description. We had just gotten through some, state files in motion. They want to sever the defendants. Trial is currently set for April 2017. We had watched the arraignment out of order. This was uploaded really late, so that was a weird little curveball. And now we're going to be up to a hearing on November 15th, 2016. So we are in that time period where suddenly Jason Autry's attorney is going to get that discovery, the 2-disc discovery with accessible versions of files that other defense counsel can't access, getting into that hotspot territory. Good morning to everyone that's in here. Good evening, depending on where you're living. Good to see everybody. We got Boop Furrow Bailey's in the building. Alexi's here. Yeah, the hat is a win. Thank you, Louise. Good to see you. Shout says, I wish everyone could dance and clean over here. Oh, is that what you're listening to? You're hanging out with us while you're cleaning? Love that. Good to see you, KP. And Tedsko, hello, hello. Oh, it's going to be a good time, you guys. Hit that like button on the way in. See, Mish already did it. And we've got, let me not miss anybody. Let's see. There we go. I think I got everybody. So good to see you guys. I'm trying to get better at YouTube and grow my channel. So today I made a special thumbnail where I put 2 extra faces because everybody loves them. And, if you see a thumbnail with Judge Creed McGinley, and if you see a thumbnail with Jennifer Nichols, you're obviously going to come watch, right? So I put 2 faces that everybody loves to watch in the thumbnail, hoping that people come hang out with us today. So we're going to watch. We're going to see our favorite people. We're going to see how this hearing goes. And I think they're just doing some motions.
Zachary Adams, motion 48, joining that motion. Also, Zachary Adams, 21, to consider all objections under both state and federal constitution. Zach Adams, motion for higher standard of due process. I've already mentioned at the outset that the court is aware that there's a heightened due process in death penalty cases. I will apply the applicable law to each motion on a motion-by-motion basis.
And oops, sorry, I had the wrong banner up. It was from the Courtney
Zachary
Quinney
Adams,
thing
number
yesterday.
2, motion to sever trial of Zachary Adams from Dylan Adams. State earlier filed a motion to sever. I'm reserving any severance until the court makes certain other rulings, because those rulings will impact whether we have 1, 2, or 3 potential trials. So motions to sever will not be ruled upon at this time. Number 7, Zachary Adams, motion regarding hearsay. Motion seeks to have the state specify any hearsay it intends to present as evidence in order that a pretrial ruling in limine may be had on the admissibility of the same. Motion seeks to have the witness admonished to refrain from the admission of hearsay testimony prior to the court's ruling. I intend to follow the rules of evidence. And all I can say is that if you think that something's hearsay, you need to object based upon hearsay prior to the witness attempting to respond, and I'll make sure the witness does not, and then you'll get a clear ruling on it. Motion number 16 of Zachary Adams, motion to instruct the gallery. Court seeks to have the court admonish the gallery and spectators during the trial prior to each session and out of the presence of the jury to refrain from audible commentary, visible reactions, emotional displays, or outbursts during the presentation of evidence before the jury, and to prohibit the wearing or display by spectators of any insignia, symbols, pictures, clothing, or other items that might influence. The state believes this motion is unnecessary and the court may manage courtroom decorum. I addressed this at the very outset. I intend to basically maintain proper decorum in the courtroom. I will not suffer outbursts in the courtroom. There will not be T-shirts, other things.
So he's sticking, this is what every court proceeding should be like. There's obviously an elevated need for the reminder because a lot of people are going to be shuffling in and day out. It's not going to be an empty court gallery or the same couple of people joining in and hanging out for the trial each day. But he just said, the state says this is unnecessary. Like, are they stupid? Oh my goodness.
In an attempt to any way influence jurors. I think we got problems anyway with jurors influenced by a T-shirt or a ribbon, but the court won't suffer it. I recently tried a case in Benton County that was not nearly high profile, and I just caught the people coming in and they had certain types of shirts on. I said, cover them up. You're not going to do that in the presence of this jury. So court intends to maintain proper decorum. Zachary Adams, number 18, motion to prohibit display of exhibits until admitted.
They said don't try it.
I'm not sure exactly.
Look at him.
I'm going to, in other words, opening statements, parties might wish to address something, but
That's not an exhibit, though.
an exhibit is not evidence until it's properly admitted by the court. And I'm going to ask that the parties carefully watch what they make reference to. Recently, I had in a case a PowerPoint display that I think probably went beyond what it should have concerning evidence. The jury's always instructed that they'll rule only based upon the evidence in the law, but I'm going to ask that all parties guard in their opening statements. Getting too far out on a limb is what I'm saying. Zachary Adams, number 19, motion to establish procedure to view exhibits. I'm not sure exactly what that is. Prior to anything being authenticated or moved into evidence, certainly counsel for each side have a proper opportunity to look at that. That really should be done pre-trial in order to expedite. I'm assuming she reminded me that's when the attorneys were viewing certain things at different physical sites. Yes.
Yes, Your Honor, that was for us to, the court to give us some instruction as to how it could be that the parties could look at the evidence that's in the custody of the state. We refer to it as exhibits because on many of the lists, the state had referred to items as exhibit numbers. But it was just we were looking to the court to provide some guidance.
I think I have the boost all the way up. Oh, it's not on. All right, guys, volume check. We're going to boost this because the judge is okay to hear, but we can't hear everybody else in the courtroom because there don't seem to be any microphones.
As to how it was, we were to look at
Has this been
evidence.
resolved?
It has not been resolved, Your Honor, no.
Then I expect the parties in a professional manner to resolve it.
Yes,
This is not something that should require court intervention. You have the right to have a certain amount of privacy while exhibiting, if this is where it's going, but it's not unfettered.
we didn't ask for unfettered, Your Honor. We would like to view the evidence without the prosecutor present. There could be an agent or somebody else present, but the prosecutor's office doesn't review evidence with us present. We would like to be able to review the evidence without the prosecutor present.
Can we designate an agent?
So I was thinking about this the other day, actually, mostly because of the conversation we heard in these post-conviction hearings that Jennifer Nichols is so offended that Jennifer Thompson had a recorder while she was in the exhibit room that they had for this case, looking through the evidence. And I was thinking, like, having Jennifer Nichols, any prosecutor, but especially Jennifer Nichols, breathing over your shoulder, like, if you look at something too long, that could be a hint that, oh, that's going to be important to them. So I'm going to try to get ahead of their trial strategy. It creeps into trial strategy territory to have someone sitting there like the person that's going to be on the other side of the aisle at trial, seeing what you're looking at and what you're not looking at. And sure, you could try to poker face it and throw them for a loop, like look at something irrelevant on purpose, but then that's not a very efficient way to do things. So to me, it is kind of an issue, and I don't know, is that standard that it is usually a prosecutor standing in there with you? Why couldn't it just be somebody else, making sure you're not, like, smudging papers or writing on anything?
Take care of this.
Excuse me. The problem, Your Honor, with what counsel is requesting, and we have actually attached photographs to our response showing the thousands and thousands and thousands of items. Every single time one of those bags is open, it requires one agent to open it.
Oh no, they want to
One
look at
agent
the
to pull,
evidence.
take it out, to display it, another agent to repackage it, to move on. So we were all doing it at the same time. The state was not hovering. And it's interesting because
This is from the same prosecutor that had the mom go through all of the personal affects while she was on the witness stand until she broke down and cried and passed out. It takes so long.
all of us were present to avoid tying up the entire agency, TBI I'm referring to, for days and days and days and days. The only person who complained is Zachary Adams' attorney. It was fine with everyone else. They were free to stop the process, to go and confer, to look at something, to photograph it. It is a near impossibility to ask TBI to do what counsel's requesting. In terms of designating an agent, and she, frankly, one of the requests was that an agent be designated that didn't have anything to do with the investigation. I'm not sure where all this personnel is supposed to come from, but we did our very, very best to make sure we did it.
Did we have any problems with the procedure?
I did not, Your Honor.
All right. Did y'all have any problems with the procedure?
Cat used to have lights, but the battery died.
We could come back and later time
Yes.
review individual items if we needed to.
Okay, the court finds that the state is sufficiently complying with what the court feels should occur, and you might have to come her way a little bit on this,
So
okay?
it's fine that the district attorney stands next to me. I mean, at some point, the district attorney is standing next to us.
I don't want it like the Saturday Night Live skit of Trump right behind Hillary following her around. She's got
What?
some, you know, we're human beings. You'll be given a certain amount of privacy, okay?
Yes, sir.
All right.
Oh my god. So this, I'm looking at this video and it feels like 20 decades ago to me, but this is 2016. That's crazy. I gotta like reorient.
Zachary Adams, motion to
my time.
continue, overruled. Related motion, Jason Autry, motion to continue, the trial date set April 3rd. I had mentioned at the outset that since Mr. Autry's attorneys came into the game later, that we will not hold them to that April 3rd date. They will be held, however, to the July date. You came in following two other attorneys. Mr. Show came in first, and then Mr. Parrish came in. You folks were later into the game, so I think I can give you at least that much relief. You will not be that first trial date, okay? I think that's it. Anything else? She'll get you an order. If we did not cover your motion, call that to the court's attention, and the court will do another order covering your matter. All of these are basically, they're non-evidentiary, It will get much more complex when we're taking up evidentiary motions, but I think for purposes of today's hearing, that all these matters have been covered.
We had it the first week of July, correct, Judge?
No, it's toward the last of July.
Tenth.
10th? Oh, I got this neat book here.
Look at him looking at it. Look at him.
No, July 10th. July. July 10th.
That's the alternative trial.
I got July 31st. I can do it the 10th. What did y'all get?
We have it the 10th.
Okay, chat. They're gonna get me for this, but I think this is the visual. Let me cue this up. This is the visual. Maybe I can just mute the sound. Okay. Hold on. This is what, and honestly, I feel Creed McGinley on this one. The following around. This is Jennifer Nichols and Jennifer Thompson in the evidence room. Just trying to look at evidence over here. Oh my goodness. And there's Jennifer Nichols. I'm just over here trying to go through the files, look at the evidence, the investigative reports. Jennifer Nichols is creeping up. Oh my goodness. Oh. Okay, back to business, back to business.
The first week in July was discussed as potentially starting jury selection the week before trial was supposed to start on the 10th. But Your Honor did not ever definitively rule. I think most of us just sort of blocked it off, waiting to see.
I think we talked about coming in and taking the jury a little bit earlier.
But there was some question about it with it being July 4th week, but we did have that discussion, but the 10th was.
All right, July 10th will be our trial date. What have I said repeatedly? She's telling me I've got grand jury in Hardin County during that time. Well, guess what? I don't either. I've told you folks you've got priority on this case. I've said that from the outset. This case has absolute priority, and once we get things going, I will not be interrupted. I don't think I'm going to. First trial date is April 3rd. That could apply to either John Dylan Adams or it could apply to Zachary Adams. Autry, I'm telling you, I'm giving you till July 10th, okay?
Your Honor, I didn't discuss Autry motion number 30. If you'll grant that, we'll just probably speed things up. Otherwise, we could hold that in the May.
What is 30?
For you to strike like that.
Motion overruled. I told you I'm following existing law,
Yes, sir.
and so you can, that motion be deemed
We
overruled.
wouldn't object you creating some new.
I'm all for it.
I think everybody over here is.
Crickets over here.
Do what?
Crickets.
No, I'll let you preserve your arguments there. All right, anything else? And I think I mentioned down the same avenue, we're not having two separate juries. It's bifurcated for penalty and sentencing, but we're not having two separate juries. I'm not prohibiting from going into death penalty with voir dire with the jury panel. I think those were part of the motions, but I told you as we went through that I would follow existing law on that.
Yes, sir.
All right, anything else? All right, no need to kill a bunch more trees, I don't guess, but, and this is only a portion of what I've got.
All right.
Wait, why do they stay in the gallery for so long? Okay, I guess that sounded like it was ending. I guess it's not. So he is out there. Holy moly. Chat, look at the screen. So when Jerry Gonzalez, the attorney that came on the last minute to help Zachary Adams' team, testified at the post-conviction hearing, he said that Judge Green McGinley would go out there and stand at the door where anyone that's in custody, I guess, but Zachary Adams would have to walk by every single day, and his gun would be right on his hip. Look at him out there. Yeah, so the judge has a gun, and also there's like a news story from, I don't know, like 2020 maybe. It wasn't before this trial or anything, but he was going through security trying to like board a plane or something and had it on him with one in the chamber. So very, very Tennessee. But yeah, the idea being that that's intimidating to the defendants.
And we were just funny.
To see a little bit
He should have did.
Bobo family.
I was trying to.
Somebody's wearing slime color green back there. Oh, is that Brent Booth? There's Brent Booth. Has the state found what?
Has the state found what? Has the state found what?
Hey, chat. Oh my God, I'm deaf.
Decatur County Circuit's Court now is in session. Honorable Judge Green McGinley presiding.
Be seated, please. Just a few preliminary matters.
Will they turn up all the mics?
First of all, we've got all three defendants. Got you seated where you can communicate with counsel should you need to. I will tell the defendants you are not to communicate with anyone except your lawyer or directly with the court. Okay, we understand that? Mr. Autry, you understand that? No communication with anyone other than your attorney or the court. You understand? And then Mr. John Dillon, you understand that? All right, there's a slight change. Most of our motions today are the more technical motions. They're not evidentiary motions. Those evidentiary motions will come later. These are essentially, I would classify them as housekeeping motions, but I will tell the attorneys, first of all, I'm guided by Tennessee law. I don't make law, I follow law. I'll be guided by the Tennessee Code Annotated, case law, the Tennessee Rules of Evidence, as well as the Tennessee Rules of Criminal Procedure. A lot of the motions that have been filed address issues that are actually addressed in those rules. I'll touch on them as we go through, but those rules are what will guide the court. There's a slight change. Our next potential hearing date, I originally had said December 13th. That's in conflict with Chancery Court here in Decatur County. We've got limited facilities. There's one courtroom, and I've got additional time so I can defer to the Chancellor on that day. I also avoid setting things in Decatur County on Mondays because that's the traditional General Sessions Day, and Decatur County is not high volume, but I don't want to deprive that General Sessions of their opportunity to move their cases through the system. So our next potential date here is December 14th. I've got 3 days available at that time, although I don't anticipate that it will take 3 days. If we don't accomplish in those 3 days, the following week I cannot be back until the 21st. That's a Wednesday.
I will not be here the week of 21st, just to let the court know, but I don't think we're going to go past 3 days.
Okay. I'm sure you've checked me out before with fellow lawyers or judges. You're not going to go past 3 days, okay?
I don't think we are.
So I'll just let you know that. But if it appears a problem, we'll work it out, okay?
Thank you.
And then there's potentially some dates I can make myself available, and some of that will depend. You've got a motion, Mr. Maddox, for extension of time to file a motion to suppress, and I'm worried that the timing of your motion could trigger response and potential examination by the state that might put us past that December date. When can you have your motion suppressed, ready to file? I'm just anticipating. Am I anticipating correctly?
You are, Your Honor. That can happen.
Your Honor, upon discussing with the code counsel, we think we should be able to have that filed, no later than November the 3rd.
November the 30th.
Okay, that will potentially jeopardize that December date. We'll cross that when we get there. I will tell you I've got I got 3 days starting January 11 available, and also, what did we say in February?
The 6th, 7th, and 8th.
6th, 7th, and no, see, the 6th won't work, 7th and 8th in February. 6th is that Monday. So, file by November 30, state file their response, and then we'll calendar it for hearing on one of those potential dates. If the state makes a motion for evaluation in response to their motion to suppress, then that will be granted ample time to get that done. And we're also dealing with holidays, which makes things iffy for all parties concerned. So I've already issued an order on some of the motions that were purely technical. John Dillon Adams, motion number 1, to require the state to comply with provisions Tennessee Rules Criminal Procedure 26.2 is granted. There's already been an order to that effect. John Dillon Adams, motion number 6, notice and motion under Rule of Criminal Procedure number 16, and Zachary Adams has motions that are piggybacking. It's Zachary Adams number 30, Zachary Adams number 35 for discovery and inspection. There's already been orders entered on those. John Dillon Adams, motion number 6, under Rules Criminal Procedure 24B2 and 24H. Zachary Adams, motion 36, joining for individually sequestered board hour. There's been a motion entered as to that. We will have individual voir dire, certainly on the issues of pretrial publicity, hardship, death penalty. And I will address later, but the court's open to questionnaires that will hopefully expedite these issues that can be filled out by jurors pretrial. And
Last number, Judge, I apologize.
John Dillon Adams, motion number 7,
Okay.
and Zachary Adams, 36.
Also included these 3.
Oh, the state's motion for reciprocal discovery was granted, and Jason Autry concerning reciprocal discovery and disclosures of experts. The state's complied with disclosure as to all 3 defendants, so you can show that
So we are still a ways away from Tron. Look how OG this computer is on the screen, even though it's only back in 2016. Looks like an old version of Windows in my world. This is the 15th of November, 2016. On the 8th of November, the state responded to, I think it was Jason Autry's attorneys that asked, and they say, we have no known exculpatory evidence. We know now, especially because of Doug Bates at the post-conviction relief hearings we've been watching, that what went forward at trial contained exculpatory alibi, like straight up alibi evidence. But somebody was changing the file names to remove keywords. None of the paper documents that were put into the system were OCR'd, so nobody could search certain keywords. It just buried. And everybody at the post-conviction hearings is trying to say, well, I didn't know about that ATM surveillance video footage that alibis your clients. All of that. But we are still months away from the trial. They're expecting to try to go to trial in April. This is November. And they're already granting reciprocal discovery so the state can get evidence from the defense all the way in advance. And yet some point after this hearing, I think on the 18th, it's either the 16th or the 18th, Prosecutor Nichols tells TBI agent Joe Walker to release a different set, 2 discs, of accessible discovery information to co-defendant Jason Autry only. So kind of weird. I also wanted to pause. The link that Erin just shared, she caught a still frame. And it says, point of view, you're trying to get a fair trial, but the judge has a gun and waits in the hall to flip you off after court. And you can see right down here, this little... There you go. And that's what attorney Jerry Gonzalez testified to at the post-conviction relief hearings. That's crazy, Erin. This is crazy. What a trial.
is granted upon their, they've already complied because I've got
Windows
a bundle
Vista.
as to all 3 of the defendants on that. Matter of fact, it scared Miss Carroll to death when she looked, and there were 200 and something pages from the state. But that included correct.
It jumped.
Judge,
So it jumped there, but they were saying 200 something pages from the state. So disclosures of experts of the states complied.
Defendants, so you can show that that is granted upon their, they've already complied, because I've got a bundle as to all three of the defendants on that. Matter of fact, it scared Miss Carroll to death when she looked, and there was 200 and something pages from the state. But that included correct.
So it sounds like all of their expert witness disclosure and the curriculum vitaes, the CVs. And then it jumps. I don't know if we missed anything between that jump.
That you had for November the 7th, I believe. I think by the time we received it, we may have passed on the deadlines of November the 11th. Involving the experts.
It's this one.
That was on the states turning over experts to testify in terms of opinion and interference.
They've already turned it over. I was talking about 24B2 and 24H, John Dillon Adams, Zachary Adams, number 36. As I said, that's individually sequestered voir dire is granted. Motion for change of venue will not be granted at this time, but the parties can assume that the court will grant a motion for change of venue at some point. I want to leave it in this county as long as I can, because convenience of family members of the alleged victim, as well as defendants and interested parties. So we will not change venue until on down the road, but I will tell you, venue will be changed.
That's understandable, Your Honor, but I'm going to make this request since we're talking about venue. I would ask that there are ribbons and things all over the... This is a good time to do it. It won't affect the court, correct, but it potentially could affect jurors. There will be an order of decorum that will be filed where this case is to be heard, and I will not tolerate signs, placards, T-shirts, anything like that that could be perceived as trying to influence prospective jurors. So that will go into effect wherever the court deems the appropriate venue is. And I will go ahead and tell you, just for thinking purposes, the physical change of venue in all likelihood will be Hardin County. I've already explored security and other issues. We can have very, very good security. We can, the housing of jurors can be taken care of so that they'll be sequestered appropriately. There will be alarms on the elevators as well as the stairs, and sequestration of jurors can be accomplished there.
And Your Honor, I neglected to advise defense counsel and Your Honor, but I have received notification from the Department of Homeland Security for the courthouse, and I have the number that your person to give to the sheriff or whoever you designate to get it there.
There will be metal detectors, as well as x-rays,
Right.
and potentially the dogs might be run some.
Well, they said as soon as you tell me who to give that information to, pass it on, and they'll call and have it physically relocated.
Okay. I'm also reserving the issue of where the jury is
How did he just get quiet?
to be impounded. It could potentially be Hardin County. One of the attorneys suggested Shelby County. Anyway, further than say
They're going to end up moving to Hardin County is where they'll actually do the trial. But they're still debating at this point. And it borders, it's right there.
That issue's still open, so we'll wait till we're closer to know which way the court's going to go. A motion to change the venue will be sustained, but not until later, okay? So once that motion is sustained, files and everything will immediately to the county. Mr. Tanner's doing a fine job up here for right now, although I'm sure he'd be glad to load them in his pickup truck and take them south when he is able to do so. Disclosure of expert testimony, disclosure of facts, data, underlying expert testimony, qualifications of expert testimony, that's Dylan Adams 15 and Zach Adams 44. Also Zach Adams number 5, essentially ordered that Dylan Adams motion for leave, additional motion, Zachary Adams, that's number 20, Zach Adams, 25, Jason Autry, 11, 26, and 5, court has ruled on that. Dylan Adams, number 21, motion and notice of joining of all co-defendants, pretrial motions. That's the one, and Zachary filed motion 28 to adopt. I've asked that and ruled earlier, we don't do a blanket motion to join all motions. They specifically will file that they're joining motion number whatever it is. Zachary Adams' motion regarding Rule 1006 summary of reports document. File the same motion. And related motion is Zach Adams 60 joining Autry's 25. That is granted. Motion for bifurcated jury, 15 on Zach Adams, Jason Autry number 18 for separate. I think I have ruled on that, but I will follow Tennessee law. We don't get different juries for penalty phase and guilt phase. George will be voir dire as to the entire trial. That will not be bifurcated, and then extra alternates so that we can cross death penalty when we get to it. So I think I've already ruled on that, but that will be what the court's ruling is. Motion for jury questionnaire, that's Zach Adams 15, Jason 19, state also, Zach Adams, motion 54, joining office number 9, and state has filed a motion as well. As I indicated earlier, I intend to use jury questionnaires. We agree between all parties. In other words, probably I will get Ms. Jones to first fire across the bow and then send it to each attorney for suggestions or narrowing or whatever. I think we should be able to agree without any problems. Zach Adams' motion is being closed. That's absolutely established in Tennessee law that when we're before the jury, there cannot be any indicia that any of these defendants are incarcerated because they've been ruled to perhaps detract from the presumption of innocence.
There cannot be any indicia that these individuals are incarcerated, but let's call 700 jailhouse witnesses that say, I'm in custody with Zach Adams. Come on.
So at the time we go to trial, each of the defendants, however they're tried, will be allowed to the VSB closed. Makes no difference on a hearing like this today because the court's ruling, and it makes no difference to me what their peril is. Zach Adams' motion to dismiss, because I think that's where he said that the and Autry's motion to dismiss on the grounds that no grand jury voted to return Zach Adams, all of them. That's contrary to existing law. The grand jury doesn't have to vote on death penalty, they just have to vote on the criminal charges. Of course, we ruled on Zach Adams, motion 24, to dismiss based upon Gossip versus Gross. As far as Jason Autry, there's a motion for state to seek intent to seek death penalty. I don't remember what that is, but the court's already ruled on that. Jason Autry, number 17, motion for jury penalty on specifically for this case. Did I run on that or not? It depends on where I get my jury. If the jury comes from the same place of change in view, it will be a separate jury summons specifically for the case. If I go to Shelby, Chattanooga, another place, it might not be specifically summoned, I might be drawn from that pool. All right. I said it was granted, but it's subject to those qualifications, okay? Because there's no need for Chattanooga to have a separate summons for whichever case we're trying. Shelby, they got that auditorium down there that's filled with drawers. What I have done in the past when I was over there, I met with the jury, handed out questionnaires in the morning, had them fill those out, and then we started jury selection actually right after lunch. I ruled on Judge Autry's motion for probable cause hearing on the existence of aggravating factors. The state has a motion for notice of alibi defense, which was granted. Motion, the state has a motion for notice of defense based on mental condition, which is granted. Get into the discovery-related motions. Dylan Adams filed a motion to produce exculpatory evidence or information which might lead to exculpatory evidence for the defendant. The state filed a response that court kind of questioned. Without a theory, without a statement from the defense as to the theory of defense they would be pursuing. I don't know anything under existing law that would require a defendant to disclose to the state a particular theory of defense. The court is ruling that the state must, pursuant to Brady, produce evidence for each defendant. And I'm very serious about that. I don't expect any problems. You folks are used to doing that. So let's not play it close to the chest. Anything that is of any question whatsoever is to be turned over to the defendants. And I'm aware from various things the court's done that states, through their discoveries, fully compliant. Let me just say that. As to some of the potential theories for defendants, the state has been very forthcoming with other potential defendants and other things that have been raised in motion. I expect them to continue, and there'll be a continuing duty to disclose as we go through. Dylan Adams' motion in limine under Rules of Evidence 404, 405, 608, and 609. Zachary Adams also joined in. Your motion 32. Motion seeks a pretrial or jury out hearing for any reference to any prior conviction or bad act of the defendant. Certainly that is required. The defendant seeks an opportunity to go out and cross-examine any such witness in a pretrial or jury out hearing. And the state has responded that it is mindful of its obligations and expects the court to follow 404, 405, 608, 609. But they state that the motion exceeds the provisions of the rule. Also, it refers to open discovery. I will be following those rules to the letter, so just expect that. Zachary Adams also had motion number 9 in response to 404. Request notice at least a 90-day pretrial of 404B evidence and seeks pretrial rulings. Seeks that the state will admonish its witnesses not to mention the same prior to a bench conference of the same trial. State responded to the same as above, and asked that the motion be denied. We're going to try to rule everything we possibly can pretrial so that it will facilitate the case moving along, because it's going to take a long time to try doing the best we can. Jason Autry, motion for pretrial disclosure of evidence, other crimes, wrongdoing, or acts, and for a pretrial hearing, that would be granted. Motion for pretrial on the record findings pursuant to 43404. Zach Adams joined in that, joining Autry, do everything I possibly can in pretrial. Gotta go across that language. I just, I'm hopeful that the parties are having some type of dialogue for resolution of the case. That's up to the parties, it's not up to the court. So,
Oh my
when
God.
we get down closer to trial and we realize if we've got 1, 2, or 3, which I don't know yet what we've got to be tried, then we will set time deadlines for pre-trial motions to be argued so that it can facilitate. All right, Dylan Adams has a motion under Tennessee Rules of Criminal Procedure 12B2C. Zachary Adams has motion 33, joining John Dillon as number 4.
Your Honor, that's the motion, stress we were earlier on that we were.
That you're going to have filed November 30th.
Yes, Your Honor.
Is it
That, it would be supplemented, this is just.
Okay, all right, so you know what the court's ruling is on that.
Yes.
Dylan Adams, number 5, motion for introduction under Tennessee Rules of Criminal Procedure D2. Zachary Adams is number 34, joining this motion. Defendant seeks a Rule 12D2 notice, which the state has already filed. The state did reserve the right to supplement the notice as reasonable and necessary to pre-trial. The state has indicated in its notice that because the issue of severance is currently pending, same notice has been filed as each defendant, and the state points out that any co-defendant could be a potential witness for the state. The state also noted that it will continue with other file discovery.
Judge, I'm just going to say, just for the record, that each of these, some of mine are obviously titled differently, that most of them are saying are granted for with regards to testimony.
Yeah,
I just want to put that on the record.
absolutely.
Thank you.
If you want to, just one word say that I can follow along. Because it's just technical crossing T's and dotting I's, and a lot of that has to do with the standard death penalty cases. Normally, I wouldn't be pleased that the attorneys are killing the number of trees they are, but I understand, okay? That was granted, is complied with by their request. All right, Zachary Adams, motion number 3 for Rule 12D2, notice of evidence. Shayne Austin, motion 14 for notice of state's intention to use evidence. And related motion, Zachary Adams, number 49, joining Autry's number 14. The state has provided the same notice of response to.
All right, so a lot of motions there for evidence, and not just to turn it over, but also like give us a hint what you plan to use, identify what you're going to use at trial.
This motion, these motions are essentially granted by the court as the court can comply with continuing duty to disclose. If the defendants have any.
And he's saying it sounds like it's granted as already complied with, but continuing need to dispose as necessary. Depose. So if there's new things you plan to use or new evidence you come across, obviously there's a continuing duty to disclose. But he's also saying thus far, up to date, the state has complied with these requests. So, yeah, sure, Judge, sure.
Specific issues with 12.
It keeps jumping. That sucks.
State cites open file, its alibi notice, and states that info requested is neither necessary nor appropriate. I don't want anything destroyed, is what I'm saying. And I know that there are any number of rough notes, anything else. I don't want anything destroyed so that we can assure that full compliance with Brady's being accomplished. Zachary Adams, motion number 8 regarding 804B3, exception to hearsay statements of his interest. Wants the state pretrial to specify in writing and with particularity all statements against interest that the state intends to introduce at trial. and the court to hold a pretrial hearing on the admissibility of the proffered testimony. The state has responded that its filed 12D2 notice has provided open discovery and will supplement as necessary. So any statement against interest, essentially you'll get that. Motion number 26, Zach Adams, motion for pretrial review of victim impacts evidence. State does not object, but states that it is sure the court will follow appropriate procedure. I hope so. The parties will need to follow procedures set forth in the Nesbitt opinion, and the hearing need not be pretrial. Matter of fact, this is something that can be done sometimes while the jury's deliberating the guilt phase. We can check, make sure that testimony during the sentencing phase is appropriate. Number 29, Zachary Adams, motion for agents to provide evidence to the prosecuting attorney. Jason Autry.
I should use that.
Zachary
Hit
Adams.
the like button,
motion
guys. Just bonk.
Number 29, Zachary Adams, motion for agents to provide evidence to the prosecuting attorney. Jason Autry, motion for all agents, officers, and employees to disclose and provide evidence in the possession, custody, and control of the state. The state submits this motion is not necessary based upon open file policy. Motion's intended to avoid any issue of an agency failing to turn anything over to prosecution. I think the parties are have been cooperating to make sure that all the information that's out there gets from agents to the prosecutor's office, and it'll be furnished to the defendants. Jason Autry, motion for disclosure of informants. States comply by the rule 12D2 notice.
Closure of informants.
Jason Autry, motion for preservation and production of evidence sent to other agencies. Motions to seek preservation of evidence in the event defense needs to have it independently tested. State has responded it's unaware of any such evidence sent to another agency which has not been returned. So it's in their possession. Should it require independent analysis, that will be granted. Trial-related motions, Dylan Adams, number 14, motion for exclusion of witnesses, and for the immediate instruction to all potential witnesses for enforcement of Rule 615. The court will closely enforce the sequestration rule and will instruct all witnesses that they're not to discuss that testimony or matters that have occurred in the open courtroom. Okay. Everyone in court will be advised that they're not to discuss testimony that's given in the courtroom with other people, but all persons without limitation might be brought, but court will fully...
Thanks, Jesse. New developments now.
Oh, so we're on to the next video. I guess that's how the court ends. So we're going to watch, we have like 12 minutes before Happily Angry Lawyer is going to do his live on a blind reading. Please go in there and ask him how he's going to read blind when we redirect over there. The Delphi case of Richard Allen, his appeal document. So he didn't really know much about the case itself. I'm sure he's had some peripheral, he's seen people talk about it, but he doesn't know the facts of the case. So he's just going to read what's contained in the briefs. And on appeal, your brief has to rely what's on the record, right? So I think that's going to be a really interesting read to see him go in and just go through that. So that's going to be fun. That starts in 11 minutes. We've got a few like 1 to 2 minute clips we're going to get through before we wrap this up. But if you did not see, we finally did. We got together with Dana McClendon from the Trial and Error podcast. I think it was like 3 hours long. We had a conversation unraveling the routes. So Dana, it was really helpful to have him explain what parts of the routes are important. And he's going to show us the route. Well, he did, past tense. He showed us the route that Marshal John Walker laid out after all of his testing and putting all the phone data together. And then we go through some other points as well. But it was a really, really fun stream. There were like, I don't know, every like 15, 20 minutes, even though we've done this huge deep dive, Dana would make stuff make more sense chronologically. And then all of a sudden he'd add in new layers of information or new ways that things connect that I hadn't pieced together before. So I had a great time with that conversation. I've heard nothing but great things from you guys, and it's been really nice to hear that stuff. So make sure you check that out. That is linked in the description, and it's, I think, the second most recent video in the Zach Adams playlist if you're working on the playlist. Other than that, and DV says, girl, I know this appeal. It's Walden. So I think, yeah, that's going to be a good time over on Hal's channel. It's going to be a good time. Yes, so Abby and Libby, that is the Delphi case. You've got it, Tatum. I'm going to say the names there. Not just what happened to them is really tragic, but also, unfortunately, there's a lot of cases, so I feel like I got to narrow down. Sad thing to have to do. And then let's see, we were just watching a November 15th hearing from 2016. I think this is a summary, so let's see how the news summarizes the hearing that we just watched. And maybe they caught something that was in one of those jumps.
Now in the Holly Bobo case, tonight we know the case will likely soon be moved out of Decatur County. As News Channel 5's Chris Conti explains, the judge in the case is also concerned about finding an impartial jury.
We have children in school that weren't even born when this happened.
With each passing breeze, a flap in the wind.
The pink was to bring Holly home.
But the days of the Bows in Decatur County are numbered.
There will be an order of decorum that will be filed.
Inconsequential as it may seem, it was one of the first motions Judge Creed McGinley ruled on Tuesday.
I will not tolerate signs, placards, T-shirts, anything like that.
His concern is that when this case goes to trial next year, the pink and the green that have been the definition of heartbreak here could in some way influence jurors.
I intend to basically maintain.
If you missed, I think it was our part 2 on the media coverage. So we've done a 15-part deep dive now. 3 of the episodes have all been about the contemporaneous coverage before trial. And I think it was part 2 of the media one. They showed footage of the courthouse, and the ribbons are hung up inside the door of the courthouse. It's not just like the community members are going around the town, and while you're walking to the courthouse, you're going to see support in front of storefronts and on utility poles. It's hanging on the door of the courthouse, the inside of the courthouse, these ribbons in support. And not to shame somebody for trying to support, but the appropriate place for that type of support is not inside the courtroom. It's prejudicial to the accused. So, speaking of ribbons.
Proper decorum in the courtroom. I will not suffer outbursts in the courtroom.
Nearly 100 motions have been filed on behalf of Jason Autry, Zach Adams, and his brother Dylan. All 3 are accused of kidnapping and murdering Holly Bobo in 2011.
There will be metal detectors as well as x-rays, and potentially the dogs might be run.
From the judge today, we also learned the case will likely be tried in Hardin County.
Motion for change of venue will not be granted at this time, but the parties can assume that the court will grant a motion for change of venue at some point. I want to leave it in this county as long as I can.
This was the first semblance of tangible progress this case has seen in years.
In a way, it seems like forever, and in a way, it seems like it just happened yesterday, and it's still all fresh in our minds.
Tammy Ramey is a close friend of Holly's mom. Outside of court today, a moment of reflection of what they lost 5 years ago.
She'd had a nursing career, and all of that was taken, and we don't know why.
Like the breeze here, closure may finally be on its way.
It did bring this community together, and we've not forgotten that, and we will not forget that.
Chris Conti, News Channel 5.
All right, so where was it? 6'9" fun size. I don't know where the comment is, but hey, what was that I heard about the informants was the question. All we heard was that Jason Autry's team filed a motion. They wanted the state to disclose, they wanted to be put on notice of any informants that were part of the case, the investigation. So that's all we got to hear. That's all we got to hear. Jason Autry's team wanted to know. Next, we've got, let's back out so we can get the dates.
Logistical.
All right, so now this is going to be November 16th, so it sounds like still coverage of the hearing.
Nightmares. That's how one local official is describing the high-profile trials of Zach Adams, Dylan Adams, and Jason Autry.
Yeah, all three accused of killing nursing student Holly Bobo back in 2011.
News Channel 5's Chris Conti tonight with the true cost of all of this, new at 6.
This is small town Savannah, Tennessee.
The colors of Christmas are on full display in Main Street, Savannah. But colors of a different hue are about to become the main attraction in this small town.
I totally remember. I had friends help search for her for weeks.
Kyle Bernier manages Mama Fia's Cafe in downtown Savannah.
It actually brings a lot of business. I'll come back and see us, all right? A lot of lawyers.
This little Italian restaurant sits in the shadow of the Hardin County Courthouse. The same courthouse we learned yesterday where the highest of profile trials will likely be held.
It's been years and still nobody's been, prosecuted for the murder of her, and I think it's a little ridiculous.
He's talking about Holly Bobo. She was kidnapped from her home about 45 miles from here, and yet hers is a name they know well.
Scary, definitely scary. I mean, it's not too far away from here.
It's touched the whole area.
For Sheriff Keith Bird, the trials of Zach Adams, his brother Dylan, and Jason Autry will mean logistical planning.
So when they said Sheriff Keith Bird there, Sheriff Keith Bird has been a friend of the Bobo family. Holly Bobo is the victim if you're just tuning in to this case for the first time. And he ran on, I'm going to get in there. I'm going to finally find where Holly was dumped. And so he ends up winning the election for sheriff. He takes his position on September 1st, and then her remains are found on September 7th. So that's who they were quickly mentioning there when we heard Keith Bird.
The likes of which this county has never seen.
Finding an impartial jury that knows little about the case is going to be tough.
It will likely be Decatur County officers who will be in charge of security at the Hardin County Courthouse.
Wherever the case goes, it will be Decatur County's responsibility, as far as I know, to foot the bill.
A bill that is likely to be tens of thousands of dollars.
Everybody from the bottom to the top wants to see this thing done right.
I think they can handle the case for sure.
Savannah, Tennessee may be ready for Christmas. Getting ready for a trial of this proportion, though, will look much different.
It's forever changed how we look at things and everything.
Chris Conti, News Channel 5.
All right, this one's going
The Decatur County DA is exploring legislation that might enable the state to help pay for some of the trial. That first trial is set to begin in April of next year. And here's a closer look at just where Savannah is located in Tennessee. Again, it's in Hardin County. That's about a 2-hour and 30-minute drive from Nashville and about 50 minutes away from Decaturville, where the initial pretrial hearings have been taking place. New developments in the Holly Bobo.
All right, and this last one is December 14th. So, and this will be the last clip before we finish up this stream for the day, and we're going to spill over and redirect to Hal. When we come back and start continuing this, we're going to be in the hearing for the motion to recuse the judge, and then the hearing to add defense attorney. So that's where we're going to hear more about Luke Evans. So we're going to be watching hearings next time. We're getting some actual depth, right? We got a 30-minute, 51, and 45 here. And then, of course, more coverage after those hearings. So, last clip of the day.
Murder case. Today we learned it will be Zach Adams who will go first before a jury in April. He's charged with kidnapping and murdering the well-known nursing student. News Channel 5's Chris Conti is in Decatur County tonight with the latest. This has been a long time.
Another Christmas on the horizon, another holiday without Holly.
All rise.
And yet here was her family today in a courtroom they'd rather not be
For
in.
an order requiring the state to announce which defendant will be tried first.
Progress in the case against Zach Adams, his brother Dylan, and Jason Autry has been slow.
I don't want to lose track of any of these three cases.
So by all measurements, what the judge announced today was a major step forward.
Having been said,
the state elects in our first trial is Zachary Adams.
all right, that will be April 3rd.
The first person charged in Holly's death will be the first person tried, Zach Adams, a trial which will be moved across county lines to Savannah, Tennessee.
It's only fair to the people that are interested in this case, the alleged victim's family, citizens, as far as the defendants and their families.
We heard nothing today from the defendants. Their lawyers have filed hundreds of motions on their behalf. And this is expected to be a grueling trial. The jury will be sequestered and will likely have to work 6-day weeks.
Very pleased about it.
For the Bobo's family friend, Tammy Ramey, knowing who will stand before a jury first is a realization that the trial they've waited for is finally coming.
By the time the first trial starts, it will be 6 years that Holly went missing. And it's changed our way of thinking in this county, and we're still all looking for justice.
Another Christmas on the horizon, wrapped not in holiday colors, but instead tied tight for Holly.
And we're still all behind it, and we won't back down.
Chris Conti, News Channel 5.
The judge said today he expects jury selection to last at least 2 days. Pre-trial discussions will continue at the beginning of February.
Oh, and shout out to Trial and Error Podcast. Saw their little thumbnail there. So this is where we will start next time. We've got dude in the corner here with the slime green tie. So looking forward to that. Maybe this weekend. I really got to get my Christmas stuff together. I'm usually on point, planning things, ready to go, and I am total opposite this year. But I'd love to squeeze in some short bits this weekend, or maybe do that vintage Brian Steele throwback trial rewatch. It's a trial that he was co-chair with Don Samuel, and Happily Angry Lawyer is going to join me for that. So maybe we can coordinate some time to do that before Christmas time. Good old get together. Other than that, guys, I'm going to quickly hit this end stream button, and we are going to go over to Happily Angry Lawyer's channel to watch him read the Delphi briefs. See ya in 2 seconds. Bye, guys.